Hello everyone. My name is Vinisha Jain and I am from Institute of Law, Nirma University, currently interning with the Amikus Qriae organization. This is a PPT about startups in India and recent developments in laws relating to startups. Moving on to the next slide, we shall begin by understanding the history of startups in India. On January 16th, 2016, the Government of India launched its flagship initiative, Startup India, with the aim to promote startup culture and develop entrepreneurship and innovation. A 19-point action plan was introduced by the Department of Industrial Policy and Promotion for development of the same in the country. Continuing with the history of startup in India, in the next slide, we can see the objectives of the 19-point action plan currently mentioned. It was to provide better regulatory framework for taxation and compliance, to provide better facilitation of patenting, to provide better mechanism of dispute resolution, to bring all relevant information at one place and reduce knowledge asymmetry. A Startup India portal is also available wherein information and opportunities are shared for facilitating the growth of startups. Recently, the budget 2019-20 this year introduced an amendment to Section 54G of the Income Tax Act. This amendment provides that exemption of capital gain which arises from transfer of long-term capital assessment being a residential property should be allowed. The earlier condition was of 5 years restriction on transfer of computer or computer software, which was a new asset, which has now been reduced through this amendment to 3 years. Furthermore, the minimum condition of holding of 50% share capital or voting rights has now been reduced to only 25% to enable the growth and ease the development of startups. Further, the benefit will be available on the sale of residential property on or before 31st March 2021, as is evident from these discussions. Moving on to the next slide and continuing with discussion on the recent developments on startups in India, an amendment was also made to Section 79 of the Income Tax Act. Budget 2019-20 has provided startups to carry forward their losses, which can be done only on satisfying any of the following two conditions. The first being continuous holding of 51% of shareholding or voting power, and the second being continuous holding of 100% of original shares. Proceeding further to the next slide regarding the amendments, there has also been an amendment in the company's share capital and debenture rules 2014. The ministry has increased the period of granting ESOP to promoters or directors who hold already more than 10% equity to 10 years, which was earlier 5 years from the date of incorporation. The same has been done with the view to increase the benefits for promoters or directors who are particularly responsible for the management and development of startups. Further, the limit on shares with differential voting rights from total post-issue paid-up equity capital has been increased to 74%, with the total voting power of which earlier was only 26%. Having understood that, we move on to the next slide to understand the next noteworthy amendment which was made in the Taxation Laws Amendment Ordinance 2019. In accordance with this ordinance, 2% of CSR, which is Corporate Social Responsibility Fund, can now be spent on incubators which are being funded by the central or state government by startups. Further, contributions can be made to public funded universities such as national laboratories and autonomous bodies which are engaged in research in science, technology, medicine, etc. Hence, with a view to giving benefit to startups, the CSR facilities have been diversified and the obligations can be fulfilled in accordance with this ordinance. Having understood this ordinance, we now proceed to the next slide, wherein it has been provided, as can be seen, that the budget 2019-20 has provided for category 1 and 2 AIFs, which are alternative investment funds. It has been provided herein that the pass-through of losses shall be similar to the pass-through of incomes. Further, Section 56 Clause 2 Subclause 8b now covers Category 2 alternative investment funds for exemptions in the investment made. Moreover, ESOPs, that are employee stock options, are taxed as perquisites under Section 17 Clause 2, which is required to be paid at the time of exercising the option, leading to cash flow problem. Furthermore, Section 192 of the Income Tax Act has been amended to reduce the burden of employees and employer of startups. Now, moving on to the last slide of this PPT, we must understand that after amendment, when liability of payment of taxes arise, it shall be payable within 14 days from the date of which the assessee ceases to be an employee, or on expiry of 48 months from the end of assessment year when the ESOP had been exercised, or the date of allotted shares under the ESOP. Whichever of these three is earlier shall be considered for payment of taxes. With this, we have approached the end of the PPT. Thank you.